Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about the issue of flight and consciousness of guilt. Imagine, if you will, what it must be like going from this to this. So the question is, will the issue of Donna Adelson's attempted flight to Vietnam come in as evidence in her trial? And I want to, make a little disclaimer here at the beginning because I think it's important to point out that I'm not defending Donna here. I don't want anybody to think that. I'm just teaching on a point of law that might come up at her trial. You have to be careful about where you get your news because not all news is well researched. Over the course of the last, 3 or 4 weeks, I have had some opportunity to view some of the reporting done by the Tallahassee Democrat on the Adelson case. And so the Tallahassee Democrat published an article saying that Adelson's flight was consciousness of guilt and that as a result, the state could argue that. While many of the news outlets are basing their reporting on the Tallahassee Democrats' reporting, it's worth noting that as to this issue, the Democrat is right on spot as far as Florida law goes, so kudos to them and their reporting. Now, while it is often asserted as a matter of black-letter law that flight comes in as evidence of consciousness of guilt, the law and the issue is really more nuanced than that. Flight is not always, or even necessarily, a result of a guilty mind. And in that regard, let's look at a hypothetical here. Let's assume for purposes of this example that Donna had a trip planned to Vietnam for 6 weeks, and she had a return trip ticket, and she hadn't made the statements that she made to Charlie inside the jail. Well, in that situation, her flight is probably not going to come in as consciousness of guilt because she plans on returning, or at least that's what the evidence would tend to show. But that's not the case here. So according to the arrest affidavit, Donna tells Charlie she's getting her things in order, including making trust for her grandkids, and she further states she's considered taking her own life and or fleeing to a country without extradition. And this took place after Charlie was convicted on all 3 counts for the murder of Dan Markell. So what exactly does Florida law say on this? Well, there's a case from 2006 from Broward County, and the law it's called State versus Virgo. And here's what the court said. The law is well settled that when a suspected person in any manner attempts to escape or evade a threatened prosecution by flight, concealment, resistance to lawful arrest, or other indications after the fact of a desire to evade prosecution, such fact is admissible, being relevant to the consciousness of guilt, which may be inferred from such circumstance. So again, that states the general rule that the evidence of flight comes in. But that wasn't all the court said. The court said, however, you should always be careful when you see a however in a court opinion. However, we have held that in order to admit this evidence, there must be a nexus between the flight, concealment, or resistance to lawful arrest and the crime for which the defendant is being tried in that specific case. Moreover, such an interpretation should be made with a sensitivity to the facts of the particular case. That's Virgo versus State. Virgo and another man robbed a convenience store, and they were in a truck, and when they saw the police following them, they went to a dead-end street and parked the truck and jumped out and ran. Both of them ran. Virgo was found and he was tried for the robberies. And the court was asked to admit the evidence of his flight as evidence of consciousness of guilt. And this is what the court said. In the instant case, although Virgo's flight could have been attributed to the robbery he may have just committed, it's also reasonable to conclude that he was fleeing because of the commission of another robbery 4 days earlier. Virgo had used the same vehicle, and inside the truck he had the same gun he had used and the same clothes he had worn during the April 15th robbery. The trial court did not abuse its discretion in finding evidence of Virgo's flight admissible. But this rule is by no means universal. For example, let's consider Massachusetts law on this subject. Massachusetts has a jury instruction that reads like this. Intentional flight by a defendant after he or she is accused of the crime for which she is now on trial may be considered by you, the jury, in light of all the other evidence in the case. The burden is upon the government to prove intentional flight. Intentional flight after a defendant is accused of a crime is not alone sufficient to conclude that he or she is guilty. Flight does not create a presumption of guilt. At most, it may provide the basis for an inference of consciousness of guilt. But flight may not always reflect feelings of guilt. Moreover, feelings of guilt which are present in many innocent people do not necessarily reflect actual guilt. In your consideration of the evidence of flight, you should consider that there may be reasons for the defendant's actions that are fully consistent with innocence. Now, I know what a lot of you are out there thinking right now. You're thinking, thank goodness this case is not going to be tried in Massachusetts. But that's not the end of the instruction. It continued. It's up to you as members of the jury to determine whether or not evidence of intentional flight shows a consciousness of guilt and the weight or significance to be attached to any such evidence. So, again, a very forgiving standard in Massachusetts. But even South Carolina law is a bit more forgiving than Florida law. When is consciousness of guilt admissible? So, evidence of consciousness of guilt might be admissible in a criminal trial, but first, the state must prove that there is a nexus between the conduct and the offense charged. And this is a case that arises out of I will call it an assault case. And the issue was there was one suspect, and the cops called him and said, come set up an interview. And I guess the guy was a busy guy, and it took him a week or so to get in there and do this interview. And later on, they charged him. And one of the things that they raised at trial was, you would have been in there and you would have come clean if you had been, honest and open and you weren't scared of being prosecuted. Your failure to come in was effectively flight motivated by consciousness of guilt. And the South Carolina Supreme Court was not willing to go quite that far. The Supreme Court continued and it said, in other words, the conduct must be relevant under Rule 401. Now, Rule 401 says that in order for something to be relevant, it must have a tendency to make more probable than it would be without the evidence, whatever it is you're trying to prove. In this case, consciousness of guilt. So flight does have a tendency to reflect consciousness of guilt, so it is logically relevant. In South Carolina, the Supreme Court, evaluating the conduct of this suspect in not being prompt in scheduling an interview he did not have to provide in the first place, he could have stood on his right to remain silent, found that the state did not establish a nexus between the failed interview attempts and the offense charged for several reasons. One, at the time that he was sought to be interviewed, no arrest warrant or indictment had been issued against him, and he was free to refuse to meet with a detective if he chose. The failure to appear for interrogation was inaction. In other words, he just didn't do something that he could have done. Whereas most cases involving flight or consciousness of guilt involve some type of positive action on the part of the defendant, fleeing prosecution or arrest, for example, fighting the police when they try to put the cuffs on you. And here, there was no connection between the crime and the failure to meet with the detective. As a result, the South Carolina Supreme Court essentially overturned the conviction in that case. Now, looking at Donna's case, we not only have attempted flight to avoid prosecution occurring close in time to her son's conviction, we have her telling him she was getting her affairs in order, considering suicide, which is of itself evidence of consciousness of guilt, and making plans to go to a jurisdiction without any extradition. So the lack of a return ticket is, I think, also a pretty strong indicator of flight and intent to stay away. Now, there's no statute of limitations on murder. So does flight make a logical connection to guilt here, occurring immediately after the conviction of her son? I think it does. Logically, it's relevant. But under Rule 403, even relevant evidence can be excluded if its probative value is outweighed by a danger of unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. You can count on whatever lawyers the Adelsons hire to defend her here to argue that it's unfair prejudice, given the fact that she's essentially being charged only after Charlie was convicted. And the jury might well think that there's sort of a family thing going on here and judge her not on the evidence related directly to her, but rather on the evidence of her son's involvement. Now, I'll be honest, I don't see that argument going anywhere, but I have to point out that in some jurisdictions, the evidence, though it might be admitted, would probably get a cautionary instruction, much like the one the Massachusetts jury instruction offers. And indeed, if I was defending this woman, which there is no amount of money that I could get to defend her and do it with a clear conscience, I would probably argue exactly that. You know, you're judging her on the basis of her son. That's where I'd go with it. And even though it wouldn't necessarily be effective, it's really the only string on that guitar that they have to play. Because, I mean, what else are they going to say? It's unfair because it leads to her conviction? Well, in that case, every piece of evidence is unfair. And of course, this is another one of those cases where people have talked themselves into jail. You know, she talks herself into jail by telling her son she's going to flee on a recorded phone call. And she forgets that, you know, for months, the FBI was wiretapping him and that she's on a lot of those phone calls. And from what I understand, there's good evidence that she washed the money that was used to pay the bad guys, the people who actually pulled the trigger here. Not that anybody is not a bad guy who was involved in this. I'm just saying that she's the one who washed the money. So I guess she's also guilty of money laundering. Hadn't thought about that. Anyway, that's what I have for you today. I had to spend the most part of my day today helping somebody out with a problem, and so I did not have time to make a full video today. I have to apologize for that. Thank you very much for watching. If you have the opportunity today, do a kindness for someone. And, as always, come back here and catch me on the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.